Sector Chin v. Edith B. Merriot.
Morning. Justices Sandy Derlin, Schmidt and Federico in Boston on behalf of the appellant Chester Chin. This case comes before the court in connection with a modification judgment and the applicability or not of the Alimony Reform Act. The trial judge in this case, Judge Crawford, chose not to apply the act to parties who had been divorced approximately, they got divorced in 2011, about a year before the effective date of the.
Well, I don't know whether she chose or she thought that was the legally required course to follow.
And in this case, I think the court needs to look at the context in which the amendment to Section 34 occurred. Section 4B of the session notes indicate that all existing alimony orders and judgments become general term alimony under the Act. The amendments go on to say that it will relate to any judgments or orders issued prior to the effective date of the Act of March 2012. Now, under the Act, general term alimony is held to, and the Act indicates that it shall be suspended, terminated, or reduced upon the cohabitation of the recipient. That's Section 49D. It indicates that general term alimony shall terminate upon cohabitation of the recipient. That's Section 49F. Now, in the session notes...
Retirement, I think, is what you meant.
I'm sorry, retirement, yes. In the session notes, it indicates that the Act is to apply to any judgments issued after March 2012 and is to apply, according to 4A, prospectively. And here I believe the judge took the word prospectively out of context and disregarded the entirety of Section 4 of the session notes. Now, Section 4 indicates that alimony judgments prior to March 2012 are to terminate only under such judgments, under a subsequent modification or otherwise provided it by the Act. The language right there is important because it includes a serial comma between under such judgments and under a subsequent modification, which shows that there's a list. There are distinctions in the various relief that's available under the Act, and it shows that there are three categories or types of alimony that can be addressed by the Act. 4A notes that alimony shall terminate as provided under such judgments, and I suggest that that refers to agreements or judgments made by parties or judges prior to March 2012. Right. Secondly, it indicates that it shall terminate under a subsequent modification, and I suggest that that means by a judgment issued in the future after changed circumstances are established. And finally, third, it indicates that alimony shall terminate as otherwise provided for in the Act. And that gets to the crux of this appeal because I think that clearly relates to other provisions in the Act. Here, termination upon cohabitation, or termination of suspension or reduction upon cohabitation, or termination upon retirement. Again, the crux of the issue here. The session notes go on to also, I think, support this interpretation. Section 5 of the session notes provide for relief, durational relief, given the length of the marriage. It indicates that when a case or a modification is brought solely because the alimony judgment will exceed the durational limits set forth in Section 49, that the plaintiff is to wait. There's a phase-in. He is to wait, or she is to wait until March 2013 at the earliest to bring the action.
Mr. Drilling, isn't your argument really focused on Section 4B? I mean, isn't that where you have to get into in order to get where you want to go?
I don't think so, because I think there is no distinction. The duration 4B talks about the
what shall not be deemed a material change of circumstance.
Right, and but it goes on to talk about the durational limits. But sections 49D and 49F in the Act have no phase-in. There's no phase-in provided. Those provisions have the words upon a showing of cohabitation, upon attaining retirement, relief shall be granted. There's no phase-in whatsoever, unlike the durational limits. And consequently,
But if the beginning of B says sections 48 to 55 inclusive of said chapter shall not be deemed a material change of circumstances, but you can do something with durational limits, doesn't that suggest that anything else in 49 doesn't allow it if it's a pre-March 1, 2012 judgment?
I don't think so, because I think if you look at, for example, if you look at Section 6, it indicates that notwithstanding, Section 6 talks about retirement, and I think that you have to, let me step back. I think you have to look at Sections 4, 5, and 6 in conjunction with one another, so as a method for people seeking general term relief for alimony. Now, I think it's worth noting, in Section 5, it set forth time limits and restriction when a payor may seek a modification. But there's no mention or exclusion for that relief when relief is sought under the cohabitation provision or under the retirement provision.
But Section 4 says that the Act is supposed to be prospective only, except for durational limits.
But I think, again, that ignores the serial comma in where it says upon a judgment, comma, upon other judgments, and as otherwise provided in the Act. Yeah, otherwise provided in the Act is the provisions for cohabitation and retirement. And I think,
to the extent this is ambiguous at all, could we look at the testimony and the legislative history? For example, I think, is it Senator Fernandez or I'm sorry, I don't remember, talking about, no, this is not going to affect existing except as to durational limits.
No,
then the durational limits, which is not specifically defined, but certainly used only in connection with marriages not in excess of 20 years.
I think the legislative history in this case reflects an intent by the legislature to preserve the discretion of the trial judges. I think it reflects an intent to preserve the contracts which don't provide for relief. In other words, surviving contracts, not merged contracts. I think it doesn't simply carve out, which would be in effect, three different categories, I suggest, three different types of individuals or classes that are receiving alimony. Taken to its logical extreme, if judgments prior to 2012, March 2012, were excluded, you would have individuals who bargained for the right in a merged agreement or by a judgment to seek a modification, but would be frustrated from seeking that.
Well, they could always seek modification.
Sure. And have a burden.
Well, but under a different burden of proof.
Under the existing proof at the time.
Well, yeah, they can certainly seek modification, but when the Act itself seeks to shift that burden and make it a far higher burden to
perspective.
Going forward.
Yes, going forward. But again, I think the notion of prospective relief, I think it is to apply prospectively and to not allow individuals who have already, in other words, I think it was to prevent litigants to go back prior to March 2012 and seek relief for their obligations which they had already met. In other words, to prevent them from going back before March 2012 and seeking retroactive relief for whatever obligations they may have met under this term. In other words, if someone, in this case, Mr. Chin, he had been paying alimony after he reached his retirement age. I think the word prospective would prevent him and was intended to prevent him from going back
Wasn't he
prior
already
to March
retired
2012.
before he got divorced?
No, he was
Hadn't he
divorced in
reached the
2011. So he would have been paying alimony post-retirement from the date of the divorce forward. The prospective language there, or the word prospectively, I suggest, was intended to prevent him from going back and saying, I had met my obligations at a time when I didn't have to under a plain reading of this act. You can't go back to that point.
You can't recoup? Is that what you're
You
saying?
can't, yeah, you can't recoup. You can't,
That's all it means?
because I think, if you look at the way it's drafted, it says it's to apply to all modification judgments entered after March 2011. Okay, it's to apply prospectively, but not to subsequent modifications that someone brings given changed circumstances, which would be the one's right under a merged agreement or judgment, or as otherwise provided for in this act.
Well,
And
that's
the act
because of
sets
section-
forth plain provisions for cohabitation and retirement. And so that's the distinction that the act makes out. Now, I think it's important to at least consider the context in which the act was made. It came on the heels of the Pierce case, where this court chose not to set forth a rebuttable presumption of termination upon retirement. The payor spouse in Pierce was precisely the individual that this act was meant to assist. And again, taken to the spun forward to the provision.
Going forward.
But not,
Going to help Mr. Pierce.
this wouldn't help Judge Pierce, but the reality is it was meant to allow him to seek the relief, which under Judge Crawford's interpretation of this act, he would not be permitted to do, based on his retirement alone, or possibly based on cohabitation.
May I ask you whether or not, what's left of the prospective only if what you're asking for is accepted? I mean, you want retirement, you want the cohabitation benefit. Well, what does prospective mean then if that's not under that restriction? What's left of the statute's meaning that it's prospective only if you get this, in addition to the durational limits which are expressly accepted from that?
Well,
so what does it mean?
As I said, I think it's meant to apply, not to allow recouping monies paid or benefits provided prior to the effective date of the act. I think you have to read the statute under its plain meaning in that context.
So the legislature would have said not prospective and accepted all of these things from that definition. Does that make sense?
The legislature was careful to set forth two different provisions which were separate and distinct from a traditional modification standard, a changed circumstance. In effect, they said, we're going to address cohabitation separately than had been the case prior to the enactment of the act. And the same was true for cohabitation. Those actions or those events upon occurrence and upon proof were to immediately provide relief under a general term alimony payment.
But that would affect a monumental change.
Yes, it
in
would.
the law, and clearly this prospective only is intended not to do that, right?
I don't think that's the way the Section 4A should be interpreted. I think that, I mean, again, there are three categories. It's to apply prospectively or under a subsequent modification or as otherwise provided for in this act. Why would the legislature in their session notes have included that?
Why doesn't that apply to otherwise provided? Why doesn't that apply to the durational limits? That makes more sense, doesn't it? That otherwise provided.
Well, the durational The
is the
durational limits
durational
do
limit.
apply prospectively given the phase-in in Section 5.
Well, that was according to the legislative history, to not overwhelm.
Right, to not flood the courts.
Right, that's all that was.
But doesn't Section 6, this is the section in which one who has reached retirement age or will be reaching retirement age before a certain date in the future, doesn't that mean that those folks who have met the durational requirements don't have to wait this phasing? They can come in right away. Isn't that what that's intended to mean? And
After
nothing more.
March 1st, 2013. But if the law was to be applied prospectively only, then that would mean people who reach retirement age as of March 1st, 2012, for that 1-year period, those are the only ones who could seek relief solely under that provision.
No, that's not right. It says notwithstanding the 4 requirements in Section 5, that's the phase-in. So if you have reached your durational limits, you don't have to wait those various years. If you are at or near retirement, you can go in right away and seek termination. 5
and 6 are separate entities.
They relate to each other.
They do relate, but I think you can attain one without the other. You can seek the retirement benefit after March 1, 2013, provided you're going to reach it as of 2015. You can seek it immediately.
But you couldn't.
Regardless of the duration.
How can you seek the retirement benefit? You say the retirement benefit applies, right? 49, what is it, D or F?
F.
All right, 49F applies. So you're suggesting the statute now says even if you're not retired but you're near retirement, you can go in and get the retirement benefit?
You can seek it if you're after March 2013.
Even if you're not going to retire for a couple of years?
If you're going to reach it prior to March 15, 2015.
Yeah, so 2 years before I retire, I can seek to terminate my
after March
alimony?
After March 1st, 2013, if you're going to reach your Social Security age, your retirement age.
In 2 years hence.
Yes.
I can actually seek to terminate the benefits now.
But yes, and in that context, the judge would then set the date as of your retirement age if you came before the judge prior to 2015.
Okay, that's interesting.
Again, I'm out of time. I'll rest on my brief. I would just point out, remind the courts of the holdings in Zaleski and in Holmes, particularly footnote 9 in Holmes.
Holding? You mean?
Holmes.
I know Holmes, but you said holding.
The holding in Holmes and Zaleski,
But no.
which both applied in Holmes. It applied to the case which did predate the effective date of the act.
Thank you.
Good morning, Leslie Powers on behalf of Edith Merriot. May it please the court. This case, as the panel has been discussing, is really a case of how to apply a fairly clearly written statute. Section 4A of the Acts of 123, I'm sorry, of the Acts of 211, clearly states that the parts of the alimony law, the gist of the alimony law, is to be applied prospectively. And I think you have to look at...
As otherwise provided in this act.
Well, if I may, yes, you're exactly right. So there are I would agree with my brother, there are 3 exceptions. They are to apply prospectively or under the terms of the judgment itself, which there are judgments that call for different triggerings for it to be alimony to be ended, or under otherwise provided. And I would agree that you have to read 4A and 4B together. 4B as otherwise provided, which talks about the durational limits.
And that is the otherwise provided.
And that's the otherwise provided is in 4B. And it also, that is reinforced by the fact that it specifically in 4B says that you don't need to show a material change of circumstance if you're at the durational limits. So 4A and 4B need to be read together. I would also, you really need to look at the facts of this case to make it evident why a prospective application would be completely unfair and cannot be what the legislature intended. I believe Justice Duffley pointed out, both of these folks were retired when they negotiated their separation agreement. They were both retired. There was no triggering event based on retirement because he was already there. So it doesn't make any sense that he would now be able to come in after duly negotiating, both represented by counsel, when alimony is to cease, and it didn't include retirement age, and it didn't include cohabitation. It only included the death of either client or the remarriage. And I would point out to the court that Pierce, the case that I think we all agree probably got the Alimony Act going, was decided in 2009. Now, certainly Mr. Chin and his counsel had the benefit of reading Pierce and understanding that you had to be very, very specific as to what you wanted to be the triggering mechanism. They did not include retirement, I would suggest, because they couldn't, because he was already retired, and they did not include cohabitation. The other point I think that the court needs to really think about is a public policy, bigger picture public policy point, and that is you have, I don't know for sure, but I'm going to hazard a guess, thousands and thousands of contracts that have been negotiated through the 90s, through the 2000s, up until prior to when this act is being implemented.
But once they've been incorporated into the judgments, the parties essentially agree that they can be modified in the future.
They can be modified, Your Honor. I would agree, Justice Corday. They may be modified under a change of material circumstance. They cannot be modified because there is now a new law which changes the standard.
What if the law simply said that with respect to modifications, going forward, they can be sought for some other reason? Would you say, well, no, that's changing the game? When our judgment was entered, we agreed to only one standard for modification. Now the legislature has created another one that can't apply to us?
Yes, I would. I believe that, if I understand your question correctly, the standard in Massachusetts probate law is you may move for modification if you have a material change of circumstance.
And what if the legislature said material change of circumstances
now means
or something else? And you would say, well, that would somehow affect our judgment rights, not our contract rights, our judgment rights?
Well, but the judgment is included in a contract. So I'm sorry, I'm not understanding your point.
Well, the contract is incorporated into the judgment.
And it can be merged.
Yeah.
And it can be modified.
Yeah.
And you're suggesting if the legislature just simply changed the standard?
And you would say, well, that can't possibly apply to any judgments entered before that.
That would be my position, yes.
But isn't that position inconsistent with what the legislature did that you're not arguing about? In other words, they did change the standard if you had a
Durational.
Durational limits.
They did, absolutely.
They did, and again, I want to be very clear. Mr. Chin did not move under durational limits.
No, I understand that, but I'm just trying to say that your argument that the legislature couldn't do it, they did it. And are you suggesting they couldn't even do that?
I'm suggesting that has, as far as I know...
I'm not saying it applies to your case. I'm just...
I understand. I think that they did create an exception with the durational limits, but I think that's very different than a blanket change of retroactive application, because also in the durational limits, when you look at it, there is still, the trial court has considerable discretion to continue under certain situations, even under durational limits. The way the act is written, cohabitation, no, you cohabitate, you're done. And that I think is the difference. I think it's problematic. So again, if I may, the prospective application seems to be fairly clear. I would address Holmes, because I think I should, but I think it's very clear when you read Holmes, that is a durational limits case. And in that case, the decision says that the pre-judgment spousal support, which has been paid, I mean, that's the holding, that had been paid during the pendency of the divorce, is not going to count against the durational limits. So I think the holding of Holmes not only is limited to durational limits, but it's limited to a very specific subset of durational limits cases where people were afraid, and I think I understand, that the recipient of the alimony would just, of the spousal support, would stretch out the case and figure, well, here I go, I'll get all this, and then I'll get my durational limits. So they didn't make it applicable, but they also said that you can't stretch it out, or else we may apply it against your durational limits. So I think Holmes is not not a case that is really applicable here. I think it's quite distinguishable. I think this case really centers on contract rights and centers on a fact that you have two people, both represented, that under the law at the time, which is what we should be applying, the law at the time that the contract was entered into, what was that law? You did not have an automatic cessation for cohabitation. You did not have an automatic cessation for retirement. That's what they bargained for. We can assume, I think, that Ms. Merriot gave something up in order to get her alimony. And it appears that it would be the height of unfairness to now say, well, you've given it up, we've changed the law, now we're going to take it away, and under Massachusetts law, which hasn't changed, you can't go back in and try to redo the property division. So, sorry, that's the way it goes. That interpretation is going to be extremely problematic for people who depend on the alimony to live. And it will be a happy day for people who simply don't want to pay because they believe the act now applies to them. Is there anything else? No, I'll rest on my brief. Thank you very much.
Counsel.